Saturday nights just got better.
With unimaginable excitement.
Then toes one girl make it touch it, touch it, touch it, touch it, touch it.
Ow, ow, yeah.
The most heated rap battles.
Squad for the work soldiers, but on your campo, Bema.
I play you menace ready, it be me with the top. Godzilla self chop, who be King Kong.
And of course, your A-list celebrity interviews.
I've always said this though, there can only be one Bob Marley, so definitely there should be one episode.
Me? The threesome.
Orafu comedy woman nede.
Yeah.
Nyansa.
Don't fuck.
Lighter.
With myself, Oforua.
I'm Jason Alay, and I do this with the man,
DJ Varosky.
Where the party there today? Hey mama, hey I ever say.
Angelina, you be cool in my temperature. If you call,
say cheese, take a picture. Shaka post, make a see, take a picture.
and I like boa, 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 boa.
Where the party there today? Hey mama, hey I ever say. Secure.
No topic is off limits. The pain of experiencing a miscarriage is something that can crumple your world. We're talking postpartum bodies and everything in between. And they share their story on their battle with infertility. The touching stories of the African woman rolls before you.
I was disappointed in God, in life, in myself.
How many losses have you had?
After that, we had 4 more.
What?
I shouted, I said,
We lost vision, we lost any sound beyond crying.
Our mistakes, advices, regrets, real stories, and more on We Got This Africa. Na Ashakor and her intriguing panel serve you real experiences of the African woman. We Got This Africa.
We got this.
March is here, and on MX24, it's GH Month. As part of the month-long activities to celebrate exceptional Ghanaian products and services, we're organizing a 2-day pop-up shop and sales exhibition, the Ghana Independence Fair, happening on the 26th and 27th of March 2022 at MX24, Silicon Square, Boundary Road, East Legon. It'll be 2 days of sales exhibitions, workshops, pitch sessions, a food fair, and open-air concert. Get your stand now. Exhibit and benefit from a month-long exclusive promotional package for Ghanaian-owned businesses. Visit mx24online.com to register your business now. You can also call 055 0500 555 or 024 235 5956. The Ghana Independence Fair on the 26th and 27th of March. Buy Ghana to grow Ghana.
Good evening and welcome to Spotlight. It's an honor that you should join us, spending 1 hour of your evening with us. My name is Nong Falong and you're watching MX24 Television, your home for fun, fearless and factual content. This evening we're wading into legal waters. Now the Supreme Court, presided over by Justice Jones Doche, has ruled that a deputy speaker can be counted during the formation of a quorum for parliamentary decision-making and participate in voting while presiding over the parliamentary business. This is a case that was filed by private legal practitioner Justice Abdullahi. It was filed against the Attorney General to contest the first Deputy Speaker, Joseph Osei Owusu's decision to count himself during a vote to approve the 2022 budget. Of course, different people have been weighing into this particular subject, giving varying opinions. Even legal minds have not been able to agree. But we're going to be discussing this tonight and hearing directly from Justice Abdullahi, who's going to be joining us. He's a law lecturer at the UPSA. He's no stranger to Spotlight, nor MX24. We also have Felicity Nelson, a member of Fix the Country movement. She's joining us on Zoom. Also, Professor Ajimanduya, who's a governance expert, also not a stranger to Spotlight, and Bobby Banson, who's a private legal practitioner. This evening, I'm going to let the lawyers speak a lot. So, if you are very, very, very interested in this particular ruling, you want to stick and stay on this particular episode of Spotlight. We'll be right back after this quick break. Stay with us.
March is here, and on MX24, it's GH Month. As part of the month-long activities to celebrate exceptional Ghanaian products and services, we're organizing a 2-day pop-up shop and sales exhibition, the Ghana Independence Fair, happening on the 26th and 27th of March 2022 at MX24, Silicon Square, Boundary Road, East Legon. It'll be 2 days of sales exhibitions, workshops, pitch sessions, a food fair, and open-air concert. Get your stand now. Exhibit and benefit from a month-long exclusive promotional package for Ghanaian-owned businesses. Visit mx24online.com to register your business now. You can also call 055 0500 555 or 024 235 5956. The Ghana Independence Fair on the 26th and 27th of March. Buy Ghana to grow Ghana.
Welcome back to Spotlight. Thank you for staying. I mentioned before we went on that break, we are discussing the Supreme Court's ruling. The Supreme Court, presided over by Justice Jones Doche, ruled unanimously, in fact, that the Deputy Speaker can be counted during the formation of a quorum for parliamentary decision-making and participate in voting while presiding over parliamentary business. Now, we have had different reactions to this. We've also had a reaction mainly from the lawyer. Let's take that reaction quickly, and when we come back, I'll be speaking with Bobby Banson, who's a private legal practitioner and is joining us on Zoom very soon.
Clearly, the sound is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant provisions of the Constitution.
This applies in forming of quorum for business as well?
Yes, because indeed the Constitution was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included. in the record of the corrupt. I mean, those things clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice and traditions, whenever the person presiding is a member of parliament, that person is not precluded from exercising his right to vote, exists. So I think those things of parliament were really unwarranted, and we really hope that they will not be repeated again. The Supreme Court has brought clarity on the matter, and it should guide the nation going forward.
There are only two outcomes. It's not like a football game where there'll be a draw. There would either be a win or a lose. But in this case, I think there's actually no one lost, because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, despite the fact that some of the reliefs that I was seeking were not obtained, but there's a far-reaching decision.
Okay, you just heard from Attorney General, Minister of Justice, Godfred Dame. He was very elated by the decision and the ruling of the Supreme Court on the right of the deputy speakers to vote. And he described the judgment as very simple, straightforward, and sound. You also heard from Justice Abdullahi, who's a private legal practitioner who filed the case against the Attorney General to contest the first Deputy Speaker, Joseph Osei-Owusi's decision to count himself during a vote to approve the 2022 budget. There have been other disagreements from also, notably among them, former President John Dramani Mahama, who believes that the ruling affects the independence of the legislative arm of government, and he says it may affect future deliberations in the House. So there's quite some amount of disagreement on this ruling. But let me go to Bobby Banson, who's a private legal practitioner. Bobby, thank you for joining us.
Thank you for having me, and greetings to you and your viewers. I heard you introduce my other panelists as they are not new to Spotlight.
Yes.
I hope that I'll get that privilege of being described in the same light.
We hope that we get that privilege. So thank you. Thank you. What are your preliminary remarks about this?
Well, it was an interesting decision. I didn't think that, and before, I have not yet had the benefit of the full ruling, the reason behind it. Hopefully I'll get it tomorrow. But before the decision, I did not think that the two provisions, i.e. the constitutional provision and the standing orders, were inconsistent to the extent that the standing orders must be declared unconstitutional. But the Supreme Court is the highest law of the land. They have spoken. We would have to work with it until they depart from it when the opportunity arises, if they choose to.
So we know the detailed judgment is not out. You say you've not been privy to it. But with this, does it put any ambiguities to rest, or does it rather open up a lot of room for arguments?
There are two ways to look at it. The Supreme Court went further to declare that provision in the standing orders is unconstitutional. It means that provision in the standing orders, any interpretation of it that would require or that would prohibit the first deputy speaker from exercising his right to vote when he sits as the speaker is unconstitutional, because in their minds, that is not what the framers of the Constitution intended. Now, the issue is whether or not the decision, this ruling of the Supreme Court, would have retrospective effect, so that it will mean that it would be applied to decisions or things that had been done previously. And it will depend on the reliefs that were presented before them by the person who filed the process, whether he wanted those actions declared unconstitutional. And I believe that was one of them. And so if that is the case, then it will be applied retrospectively. But going forward, it will bring clarity, because it will mean that provision in the standing orders, those rules or those orders, no longer have force. And so then the issue of whether it is unconstitutional or not will not even arise, because what we were relying on to say that the first deputy speaker does not have a right to vote when he sits as the speaker, that provision in the standing orders is no longer there. Because once the Supreme Court declares that a provision in any statute is unconstitutional, it means that that provision is amended and deleted from the law books. And so it is no longer there.
Wow.
But we have Parliament as a master of its own rules. So even though
some people have said that.
Hello?
I said some people have said that.
Yes. So even though the Supreme Court's decision is binding on Parliament, it doesn't stop Parliament from going ahead to amend the standing orders to make it very clear, so that they can decide to say that despite the provisions of the 1992 Constitution, this is the position of Parliament, these are the rules we are adopting to bind ourselves, or draft the standing orders in such a way that it will sync with the provisions of the 1992 Constitution. But Parliament, as a master of its own rules, can decide to pass laws that would depart, I won't say that challenge what the Supreme Court have said, but give effect to what the Supreme Court has said in a way that will remove any ambiguity as to whether or not the first deputy speaker has a right to vote if he sits as the speaker.
You know what's very interesting is the unanimous nature of this ruling. 7-0, so there was no confusion among the judges.
Well, it's not strange. We've had issues where it's been split down the throat. Others too, it's been, all of them have agreed. It only suggests that they wholly bought the arguments of the Attorney General, and so there was no room for any ambiguity as to what they decide or what they thought was. Normally, in such instances where it's a split decision, like 3-4, it makes room for review, so that you would see if when you apply for review where the numbers of judges are increased, whether you would have one person, swaying to your side. But it is what it is. And once they've had that decision, we want to see what Parliament will do next.
Well, a lot of people have been disagreeing with the ruling. Among them strongly has been the voice of the minority, and they have been speaking on that particular ruling. Let's listen to them quickly and come back to the discussion. Bobby, if you'd give me a minute. Thank you.
Okay. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. Judicial support for e-levy for a struggling economy in distress, and judicial support for the restoration of a matter that they have said is constitutional, is repugnant to the provisions of Article 102 and 104. But what can we do? They are clothed with the mandate and authority to interpret the law. This is a travesty. This is a travesty of parliamentary justice and a step in the growth and development of multi-party constitutional democracy built on the spirit and principle of checks and balances.
And that was Minority Leader Haruna Idrisu, the Honorable Haruna Idrisu, heavily disagreeing. He calls it a travesty. Let me come back to Bobby Banson, you're a lawyer, or the Honorable is also your learned colleague. But what avenues are open for them to disagree legally? Or is it just going to be banter back and forth?
Well, he's a very senior colleague at the bar, I must say. But he was speaking in his capacity, I'm sure, as the minority leader in Parliamentary. I would have thought that when this matter became ripe, the minority in Parliament, since they were the ones, they had an interest, would have maybe filed people's brief. By that, what I mean is that they could have decided to have filed before the Supreme Court legal argument to support the case that they are making, but they did not. I don't want to think that there will be any room for review. The best way is to use the numbers in Parliament and then amend the standing orders to remove any ambiguity as to whether or not the first deputy speaker would have a right to vote in that capacity if he sits as a speaker. In the absence of any ambiguity, then there will not be anything for the Supreme Court to interpret. And so that is, as it stands now, that seems to me the only avenue left for them.
We've also heard some MPs suggest that they're not going to permit the judgment to be enforced. Do they have this option?
No, I mean, that's, I'm sure that it's a political speech. I do not think that as such high persons in our society who uphold the laws that they pass, they would want to try and say they will not enforce. This is one that cannot be enforced by any of the rates of executive. They've made declarations, they've interpreted. It's left to Parliament to see. If the first deputy speaker has to sit and they count, I don't know how they would say they will not enforce it. Are they going to prevent him from sitting, or are they going to prevent him from voting? I don't see how they can achieve that. The best is to use their numbers, get one or two from the majority side or from the MPP side, as it were, and then pass standing orders that will take away any ambiguity or any unconstitutionality, as it were, with the rules that have been now declared as such by the Constitution, by the Supreme Court.
Well, this seems to be a very heavy matter of interest. We know the President has also been weighing in to give us his side. Let's listen to that. We can't avoid listening to that after all of these. And then we'll continue again with the discussion. Please stay with us.
Our Speaker is expressly not a member of the Assembly. That's why he doesn't have the right to vote. In fact, he didn't really want not even to participate in the deliberations of the House. He's a referee, making sure that the debate is conducted properly and that the rules of procedure, the orders of the House are complied with. That's his role. But he ought, strictly speaking, not to be part of the proceedings of the House. That is not the case with the deputy speakers. And that matter is transparent on the face of our Constitution. Indeed, even the presiding members of our district assemblies, they have the right to vote. Look at the district assembly law, because they are members of the assembly. And once you are a member of the assembly, you're representing certain constituencies. If you are denied the right to vote, it will mean it is tantamount to denying the right of the people you represent to have a say in the decision of the assembly. That would not be right. So I couldn't understand what all of this furore and controversy that was artificially generated. We're being told that the decision of the court amounts to judicial interference in the work of Parliament.
And that was President Akufo-Addo right there, giving us his side of it, of course, agreeing with the Supreme Court ruling. Bobby Banson, over to you.
Well, I would have wished that he did not.
Why would you? He has an opinion, clearly, and his opinion sides with the ruling.
It was a very active lawyer.
He's also your senior learned colleague.
Interest in constitutional law matters. But, I mean, at the end of the day, the Supreme Court has delivered their decision. His comments or otherwise would not have made any difference. Remember, it is not all the time that the decision of the Supreme Court may favor those in government. We've had instances where the Supreme Court has delivered a decision that did not go in favor of the ruling government. So in that instance, is the president going to comment and say, I do not agree with the Supreme Court, and what will be the consequences of such comments? So I would have wished that he did not, but he has. He's a human being, he's a Ghanaian, he's a lawyer, a constitutional one as such, and so speaking in that capacity, yes, his comments are welcome. The fact that he's a president does not deny him the right to. But if I were in his shoes, I would have decline to comment and say what the Supreme Court has said. We're binding by it. But it is what it is. Like I said, I would want to see how Parliament would carry on going forward, and whether or not, if the tables turn, if the minority now becomes the majority, they would want to take advantage of the Supreme Court decision now, or use their clear numbers in the future if they are able to get, maybe next year, next 4 years, I don't know, to amend the standing orders and then take away any ambiguity or unconstitutionality and see how we progress from there.
How do you think this is going to affect parliamentary proceedings going forward?
I definitely, the decision will favor one side, and I'm sure that they would be happy and make it
for
very
now.
Clear.
I think it's a momentary thing, because the situations keep evolving. You don't know who's going to favor tomorrow.
That is what I said first, that those who are in the minority now,
yes,
if they get into majority, I would want to see what they are going to do. Because in that instance, they may have the right, or they may select a first deputy speaker. And I would want to see whether they are going to, hold on to this constitutional provision, or say that, no, we never really agreed with it, so we would amend the standing orders to make it very emphatic. And it's a constitutional provision. They can actually amend that constitutional provision using the, the right processes. So let's see what they will do if they get the power or the authority to. And then we would see whether they truly disagreed with the principle of law, or they only disagreed because it wasn't in their favor.
Thank you so much. Bobby Banson is a legal practitioner, private legal practitioner, and he has been giving us a bit of legal insight into the Supreme Court's ruling. We're very grateful for your time. I will be moving on to other panelists, but thank you and have a great evening.
Thank you for having me.
Thank you. Now we are joined by Professor Ajimandia, who's a governance expert, and I'm just going to quickly go over this with him. Hello, Prof. You are also one of our favorites on Spotlight. Good evening.
Good evening. Thank you for having me.
Thank you for joining us. So what are your reactions to this Supreme Court ruling, if you have been following?
Yes, I've been following somewhat, because I'm not in Accra, so I'm not fully appraised of it. But I know the issues. I know that the Supreme Court has ruled that the deputy speakers can cast their votes when they have to make some decisions in Parliament. And that, of course, seemed to have offended the opposition NDC, and all kinds of statements are being made by the members of the NDC. My position is simple. First, I can sympathize with the NDC, because this decision has to be placed in a context, a larger context, broader context, for you to appreciate and perhaps to understand why the NDC appear to be furious about this decision. First of all, the balance in the Parliament is, power in the Parliament is very much balanced, almost equal numbers. And we have been fighting over this e-levy for months. And everybody knows that this is a power over numbers. And therefore, if it tilts in favor of the NPP, then perhaps the e-levy is going to be passed. So the vote of every member of the NPP is quite important for that party. And that's why this decision seems to have favored the NPP. But whatever it is, I think it's important in the name of democracy.
But Prof, either way, someone would have been favored, right?
Yes. Oh yes, of course. Unless you go to ADR, what we call alternative dispute resolution, where compromises are made in the court, it's either guilty or not guilty. You see, it's straightforward. So certainly one side is going to lose. So whichever loses in this case, I think it's important for them to accept that in a democracy, these are the kinds of institutions and decisions of institutions that we have to abide by in order for the democratic wheel to keep moving. Because if you refuse to accept it, then you undermine the basic principle of democracy. So all I can add to that is that despite the pain that the NDC may have in this particular case, I think it's important to place our interests as a nation which is maintaining and sustaining the democratic concepts here. Otherwise, we are going to undermine the very principle upon which we are developing our country.
So you think they should step back with the objections?
No, you see, there's a way out. If, in fact, they are not happy, there is what we call judicial review.
Okay.
They can go for it and file an appeal and see what the court will say.
Okay.
If the court still affirms this earlier decision, then that's the end of the road. And in our country, there's no other authority beyond the Supreme Court when it comes to matters of litigation. So what the Constitution, they are abiding by the Constitution. I think that it's important for all of us to give some kind of respect to the key institutions of our democracy. Otherwise, we will be undermining the effectiveness of the democratic practice that we want to have here.
But will this in any way affect parliamentary proceedings, especially relationships between both sides of the House?
Well, certainly, you know, already I would say we don't have a very smooth relations between the two sides, especially since they coming into the public domain of the e-levy. I don't think there's any relation between the two sides. And also, I understand that some NDC members are threatening to block the proceedings in the parliament when it comes to this same matter. But you see, the parliament, even though we like to say, is the masters of its own rules, constitutionally, parliament cannot make any rule that contradicts the Constitution. So if the Supreme Court, for instance, is saying that a certain standing order conflicts with the Constitution, so be it. It might not, certainly, it might not be favorable to this or the other party. But what the Supreme Court says is what stands. So, as painful as it may to my good friends in the NDC, I think it's a moment of truth in terms of showing commitment to what all of us have decided to commit to, which is constitutional rule. If they are not happy with any provision, if they are not happy with any ruling of the Supreme Court, they should just pursue all legitimate means, including using available legal means, but not obstruction in a violent way, as we have been seeing in the parliament. These guys have gone to fist fights for I don't know how many times over the past few months. We don't want to see that. And I think, as I said, this is a moment of truth. It's going to test their patience. It's going to test the resilience of the institution of parliament, as well as all the democratic institutions. And I think people who have been voted to be the mouthpieces of our democratic practice, especially parliamentarians,
Okay, Prof. I'll come back to you shortly. The line is a bit shaky there. We're just going to try to stabilize it. Is it clearer now?
I get you, but I don't know about you.
Okay, I hear you now. Your line was freezing.
Okay.
Right. But let me bring in our other panelist, who's Felicity Nelson. Sure. She's on the line. I'm just going to draw her in. Please stay with me. Don't leave. I'm coming back to you shortly. Felicity Nelson is a member of the Fix the Country movement, and she is on the line. Hello, Felicity.
Hi, Noak. How are you?
Very well. How are you? I have no idea if you've been following the Supreme Court's ruling. That's what we've been discussing so far. Professor Ajimanduya was just saying that we need to, you know, it's a commitment to constitutional rule, and the NDC has to understand that responsibility given them. But in summary, we know that the Supreme Court has unanimously ruled that the Deputy Speaker can be counted during the formation of a quorum for parliamentary decision-making. He can also participate in voting while presiding over parliamentary business. This is the main issue here. This is a case that was filed by Justice Abdullah, a private legal practitioner. He's also joining us shortly, in fact. And it was filed against the Attorney General to contest the first Deputy Speaker, Joseph Osei-Owusu's decision to count himself during a vote to approve the 2022 budget. What are your observations where this ruling is concerned?
Okay, so First of all, I just want to say this. Laws, decisions made by judges are not always, laws are not functions of justice. I want to say that. So something being legal doesn't mean that it's just. Just because a judge makes a decision doesn't mean it's the right decision. And I think that I can appreciate that, of course, we live in a system and certain people need to make decisions and judges must be able to make decisions. But just because they make decisions doesn't mean we have to agree with them and just say, oh, just because the judges have said it, then it's final. It isn't final. I don't agree with their decision. I think that it opens up the Supreme Court to criticisms about them being political and, you know, having an agenda. I think it can open them up to those things. And, you know, based on previously what has been done. And that this whole idea of a deputy speaker casting a vote hasn't been done before. And then suddenly someone does it and suddenly it's okay. Why wasn't it done before? So as far as I'm concerned, this isn't something that I agree with. I don't agree with the Supreme Court decision. I do. What do I think about the NDC? You know, I saw Sam George make some comments about the fact that, like, basically they're going to. Anyway, as far as I'm concerned, the Parliament should have always been in a position to be checking executive power and executive excesses. So if the executives are going to be tabling things to Parliament, I want them to check them. And if that means that we can't approve of the budget, so be it. The executive is going to need to learn. It's not for nothing that Ghanaians voted in a way which made us end up with a hung Parliament. It's not for nothing. It's because Ghanaians were so tired of us having a rubber stamp Parliament which continues anything that comes along. They say yes and they agree. We wanted a Parliament that will start to ask questions. A Parliament that will say no, stop, pause, I don't agree with this. We're not moving forward with it. So the executive needs to learn to engage with Parliament, with the NDC MPs, with the public. And when the public, something like the e-levy, this is something that is, the public does not want the e-levy to be passed. But the executive is hell-bent on passing it. So as it stands right now, it's actually the NDC MPs in Parliament who are actually representing the interest of the average Ghanaian. You can do a survey. There's been many surveys which have been done which have shown that the e-levy is extremely unpopular with Ghanaians. These people are supposed to be representing our interests. So if the NDC now is going to represent our interests and stop them from being able to pass the budget just because of the e-levy, then so be it. As far as I'm concerned, it's good. It's good for democracy. We have too much unchecked state power and it needs to be checked. So as far as I'm concerned, I'm very pleased with that trajectory. So if they're going to stop them, if they're going to question them, if they're not going to be rubber stamping things, fantastic. It's a win for Ghana.
How do you think MPs I'll come to you shortly, Prof, in a moment. But how do you think these MPs can foster unity in Parliament, especially during these times when there seems to be so much turbulence between both sides?
Well, I think the majority, for one, needs to eat humble pie and sit back and say, okay, you don't agree with this, what can we do to make it better? But, you know, the arrogant attitude, you know, kind of throwing their weight around, we're going to pass it regardless of what you do, we're going to, okay, now we're going to make sure the deputy speaker can vote. All of those kind of things does not enhance, it doesn't enhance unity. Right? So you have to go back to the table, get rid of the arrogance, because there's been a lot of arrogance. I'm not saying that the minority are not arrogant, but right now the majority need to understand that they're not in the position to be arrogant. They need to be humble and they need to engage. But, you know, kind of treating the other MPs as their enemies and, you know, not wanting to listen. They need to, because they're not listening to Ghanaians, they're not listening to the minority in Parliament. They need to sit back and listen, do less talking, more listening. That's why if they want unity to prevail, because they think they have the power, because they're the ruling government, so they think they can do whatever they want. And now suddenly they're being checked and they're very uncomfortable. So they're the ones that need to change their behavior.
Interesting. That's Felicity Nelson. She's a member of the Fix the Country movement. But Felicity, stay with me. Let me bring in Prof. Sajumanduya. It seemed like he wanted to react quickly to something that you said. Hello, Prof.
Oh, no, I'm totally in agreement with what my sister has said.
I see.
Because we all need a parliament that is effective in checking the executive. My only plea, and in fact, she's right, the minority has every right to check on the government and make sure the right things are done. It's also true to say that not every legal opinion will bring about justice. Because that's a different thing when you're talking about the law. So I agree. My only plea is that because we are all in this together, and I agree that there should be a law. People have been saying this for months. The government needs to engage. I personally do not know why that engagement is not happening. I really don't know. But in a case like this, the only thing that can resolve the conflict is for the two sides to engage. And there should be no arrogance on anybody's part. But after I've said that, it's also important to stress that once the court has ruled, as painful as it may for one party, for the sake of ensuring the sustainability, stability of our democracy, it's important that we respect the ruling of the court. You don't have to agree with it. You can criticize it any way you want. And I do that oftentimes. So it's not a matter of somebody shouting somebody down from criticizing the decision. No. But after criticizing, we are required to observe what has been ruled. That for me is important, because if we don't do that, then we'll be subverting the very foundation upon which we are trying to build our country. Look, if today MPP is behaving this way, fortunately for us, in our country, we have been alternating between these two parties. So one can predict that NDC can come to power very soon, or any other, So when it comes to them, then they should take note. I think, as the lady was saying, there are certain things that we find wrong in the Constitution should be corrected. Look, when we talk about constitutional reforms, and I'm very much for that, and it just disturbs me that none of the parties seem to be interested, either because both of them have vested interest in the status quo, and therefore they are not interested in touching the Constitution or not. And that, for me, is the problem. All of us agree that there's some fundamental issues of our Constitution in terms of the excessive powers we have lumped on the presidency, and so many other things we can talk about. So, if today NDC is not happy, I'm challenging them. Next time they're in power, they should initiate a process that will lead to reforming the Constitution to a level that all of us will be satisfied with.
Prof, do you see this particular ruling deepening partisanship in Parliament? Because, some have argued that the Speaker, while presiding, should be as neutral as possible. But if you're presiding and everybody knows where your vote is going to go, does it help proceedings in any way?
Well, see, I'm not a lawyer. What I understand is that the Constitution stresses the neutrality of the Speaker, but not the deputy speakers, because deputy speakers come from political parties. But the Speaker of Ghana's Parliament is neutral. That's why when my good friend, Honorable Do Ajaho, was selected Speaker, he had to abdicate his seat in Parliament. You know that, okay? Because he's expected to be neutral. But these two deputies are always keeping their seats. And that tells you that perhaps they still continue to function as parliamentarians. And if that's the case, then I don't understand why they cannot vote. Again, I'm not a lawyer, but I'm just looking at the practicalities of it. So I think the Supreme Court decision is elevating the Speaker, who should be neutral at all times, while the two deputies perhaps can vote. Now, somebody said all along, this is what we've been having. But this is the first time we are faced with a situation where we have to get the Supreme Court to intervene, because there's a serious confusion over whether or not the deputies can vote. And that's what the Supreme Court has done. So if you ask me, sure, for the Speaker, there's no question at all about that. For the deputies, the Constitution is a little bit silent on it.
Right. Let me go back to Felicity with the same question about partisanship during business in Parliament. Felicity, if you can just give us your opinion on that.
I don't think it's deepening. Let's be honest, our parliament is extremely partisan. All the people vote. If you're MPP, what the MPP is saying is what you. So there's nothing particularly new about them being partisan. Let's be honest, like how many times do we see any MP coming out against their party's position? So there's nothing new here. So it's not deepening it, it's not making it worse. It's just, for all it is, it's really just right now we're getting to see it, I guess a bit more clearer because there's a... Sorry, I keep...
That's okay.
Yeah, sorry. So because there's a clear opposition now, you have like a hung parliament, so it's a bit clearer, but it's nothing new. It's nothing new. You get it. It goes all the way down to people who support a political party. If they support NPP and NPP says blue is green, everyone who supports that party says blue is green. If they support NDC and NDC says blue is yellow, everyone who supports NDC says blue is yellow. Like so it starts from the top where it whittles all the way down. So it's not new. Like I'm a bit surprised that it's not new. It's not new. It's very very top. Yeah.
Thank you so much, Felicity.
I just wanted to comment on the whole. But once, even though they're deputy speaker and they represent a party, at times they play the role of speaker when the speaker is not there. So when they're playing that role, should they not be neutral at that time? Because the minute they start playing the role of speaker in that moment, there has to be a sense of neutrality. Because in that moment, if the speaker must always be neutral, then the person playing the role of speaker at all times, regardless of what their political leanings is, should be a neutral player. So I guess that's what I want to end on with this conversation.
Actually, thank you so much.
If I can just quickly respond to that.
Prof, please do.
That is very logical. That is very logical. But unfortunately, logic at times contradicts legality. So what the Supreme Court has done is not to be logical, but to be legal. That's what the problem is.
Right. Yeah, but we want to be logical and legal. I prefer that.
Okay, let's pray for that.
Is it possible for the legal and the logical to work hand in hand or agree at some point?
We need it to work hand in hand.
Right. All right. I hope we can. But you see, the political context right now is such that I'm not going to say somebody is not being neutral or not, but certainly we are having a serious political challenges on our hands today. And that's why perhaps we are all looking at this particular judgment from different perspectives.
Right. Let me just take a different opinion. And this I picked from social media from Professor Stephen Asari's post. He's a legal practitioner, and he's one of the people who vehemently disagree with the ruling of the Supreme Court, and he has been expressing his dissatisfaction. He has raised a number of weaknesses of the decision and its consequences on the future of democratic dispensation of Ghana, as he calls it. Now, he says overruling the standing order that requires the Speaker to act as an unbiased umpire with no vote makes mockery of to-fore and could very well be a Pyrrhic victory of style over substance. That's what he says in a specific article he shared on social media, which was reacting to the ruling of the Supreme Court, of course. He also provides a few instances to consider. He says, consider Order 225, which provides that the chairman of a committee shall not have an original vote, but in the event of an equality of votes, he shall give a casting vote. Now, can the Supreme Court declare the order unconstitutional because it deprives the chairman, therefore his constituents, of an original vote? He does not think so. He says, I think not. Nor can the court, he says, in his opinion. He says it to invalidate the casting vote because it makes the chairman a sole appellate judge of the committee's decisions. Interesting. A lot of people have been weighing, like I mentioned. Some have said the minority can go to court. Will the minority proceed to court? We are not certain yet, but let's take a listen to one of those.
I don't know what ruling that have gone against the minority in particular, that they have not bastardized. It's embarrassing in my view. Even when they have gone to court and they have failed to provide evidence, they still call their own failure to provide evidence to support their claim as an aberration. They're entitled to their view. When it comes to legal interpretation, I really don't have hard feelings about them. We read the same language, but people interpret them differently. That is why there's often disagreement as to what is the meaning of A or B. Sometimes, how we have grown up, the things we have experienced over the years, influence how we interpret things. And so, when the final judgment is given by the body that has the power to do that, well, what other people think does not matter. what becomes the law is what is given by the body that has the authority to do.
The same language, different interpretations, he says. Of course, there have been a lot of interpretations, but there's also been a reaction from Joe Wise. He's the first deputy speaker. He says he feels vindicated, and for him, there's absolutely no confusion. Let's listen to that too.
A long argument between myself and the majority leader. He argued that, in his view, a deputy speaker presiding was entitled to a casting vote. I said that reading the constitutional provision, I tend to agree with him, but I will not make that pronouncement because it is not so clearly stated in the standing orders and the constitution. I'd rather that a body other than me will make that declaration. So I'm very glad that indeed that clarity has been given, but I'm not surprised. The text of the Constitution was very clear, and even that Article 1093 was clear that you shall not retain the original vote, whereas in the case of the Speaker, it said you shall not have either original or casting vote. When it came to the Deputy Speaker, it said you shall not retain the original vote. The natural consequence was that you would have a casting vote. This decision of the Supreme Court appears to affirm that position that was strongly argued. I agreed with, but I just stopped short of making that declaration because I thought if we had to make that declaration, I would have preferred that it would come from the Speaker or the House voting that it should be. But what the Supreme Court has done, in my view, is to clear the way to remove any ambiguities in that.
And that was Joe Wise there weighing in, clear his opinion, very clear. But let me come back to Professor Baffour. Prof.
I'm here.
Do you still stand by your
I'm
initial?
Here.
Yes, still your initial reaction.
Oh yeah, I have no reason to change. I just want us to have a respect for institutions, no matter how we disagree. You see, because you have to be looking for the stability of our institutions. If our institutions are bastardized, where do you go when you have such a case? We cannot take your case beyond the borders of Ghana. You can't go to the Commonwealth to adjudicate in this kind of issue. So it's important that when we feel offended by the ruling of the court, we can criticize it as much as we can, but at the end of the day, let's give due respect to the institutions. That's all my interest in. And I think in the beginning I said the same. That personally, I sympathize with the NDC because if you look at the larger context of this issue, the fact that the numbers are even, the fact that there are some cases in court against certain MPs and all, it seems like there's some deliberate attempt to tilt the numbers in the favor of one of the sides. So I can understand. Nonetheless, look, I don't know whether we can go to the US Supreme Court for this or in The Hague to resolve our differences. This is what we have. So let us, with any opportunity we get, let's try to refine our laws. Let us refine our institutions so that we can get better. I agree, there are so many defects in the way we are managing these constitutional issues, but I will never call for the obstruction or the undermining of these institutions. No.
Right. But we also know there are some arguments that say this is a judgment that was forced to enable the e-levy pass through. Is that something you think you agree with?
No, I have no idea about that. And I cannot read the minds of the Supreme Court. Of course, in such a case, people can speculate. People can do their connections, connecting different facts to make an argument. I can respect all that. But so far as I know, the court never said we are doing this to help the e-levy to pass. Okay? As I say, reasonable people or people who think otherwise may make all those connections. But I think it's wrong on my part to even think that way. I think the court looked at the law. And again, I know that the people are saying the court just looked at one side of it. They didn't take the other provision, the Constitution, into account. The guy, a good friend, Justice who went to the Supreme Court, won with one case, referring to one particular provision, the Constitution, and the court ruled on that one specific case.
Right.
If you had gone with that and other provisions, I'm sure the court would have made its ruling. So far as the ruling is on just one provision that has been challenged, I think I'm okay with it.
Right. Thank you so much, Prof. But let me go to Felicity for her reaction to that and her closing remarks. Then I'll come to you too.
So I don't agree with Prof on the very idea that we can't bastardize certain institutions, because systems such as apartheid, colonialism, slavery, these were all systems which were sustained by courts. And if people didn't bastardize those systems there, they would still be in exist. Well, some of these slavery still exists, for example. But my point is, so the very idea that we can't bastardize them in the name of peace or democracy, I don't agree with that. I think that actually, if when they are going wrong, we need people to bastardize them more. And we cannot exchange what we call, let's say, peace in exchange and a place where there's injustice and say, well, peace or democracy means more. What is a democracy where there's no real justice? So I don't agree with that point in general. But if this is all the reason why, all of these issues are part of the reason why we at Fix the Country have asked for a new constitution. We've asked for a new constitutional review, because we've had a constitutional review, and what did the parties do with that? Absolutely nothing. And of course, the reason why they don't want a review or even a new constitution is because the current constitution favors you when you're in power. The winner takes all, it favors them. And I really doubt that if the NDC came into power tomorrow, that they will do anything to bring in a new constitution. So I think that this should be something that we as the populace should really be pushing for, because if we're going to wait for the politicians to do something which actually works against their interests, we're going to be waiting until eternity.
Very interesting, but because you're just on that train of thought, let me bring in the comments of Minority Leader Haruna Idrisu, who's also been speaking on that specific subject. Let's take a listen to him.
The judiciary of Ghana is also failing Ghana's parliamentary democracy in their inability to appreciate the true meaning of Article 110 of the Constitution, that Parliament shall by standing orders regulate its own proceedings. When we regulate our own proceedings, and today reference is only made to the 1992 Constitution and not to the standing orders of the Parliament of Ghana, and in particular, Standing Order 13. Today, as we speak, the Speaker is indisposed. There is a presiding person in the first Deputy Speaker. So, for your purposes, can you imagine what will happen in Parliament? While the first Deputy is presiding, there is no second Deputy Speaker available who will preside to supervise him voting for our purposes. Repugnant and unreasonable decision. He is presiding, so where he is presiding, and the second Deputy Speaker for some purposes is not immediately available in the chamber, he will walk down, vote. At that time, there will be no person presiding over the Parliament of Ghana. This is a judicial support for President Nana Addo Dankwa's e-levy that he is laboring to pass. We remain opposed to it, stitch by stitch, clause by clause, article by article. When it is presented, we will fight back strongly with our 137 vote. From today, maybe there will be a new definition of who a first or a second Deputy Speaker is.
Interesting comments from the Minority Leader, Honorable Haruna Idrisu, over there. Felicity, I'll take your closing remarks.
Well, the thing is, you have to want. I think it's good that they're opposed to the e-levy. We support them in that. But I do hope that if the tables were ever reversed and they were bringing in something draconian, they will still hold the same position and wouldn't take on an arrogant front. I think that I agree with him. Because if you think about in terms of its logic of the deputy speaker stepping down to take the vote, moving back, it just sounds very, very ridiculous. And but I hope that we're going to this decision, they're going to take it for judicial review, because again, the person only cited one case, so maybe they need to take it again. They need to take it back with all of these other instances and have the judges have another look at the decision. I just want to say I find it very interesting that recently the Supreme Court seems to only make unanimous decisions. There's no dissenters. Just say everything, yeah, they all agree. Are we not worried? Okay. Anyway.
Thank you so much, Felicity. Felicity Nelson, who is a member of the Fix the Country movement. Let me come to you, Prof. If you give me your closing remarks, please.
My sister has made me laugh so much. I think we should all be worried indeed. We should all be worried. And as I've said already, my sympathies are really with the NDC on this matter. And I think it's very important for government, in this case the president, to find some way to engage the opposition. It's very important. In a democracy, what makes it work better when there is engagement and compromises is very important. But I don't see it in this particular debate. I think the president, as a leader of the country, has the responsibility to ensure, in fact, if he wants his bill to pass, to engage the NDC in ways that will bring about some kind of compromise. Other than that, the NDC, well, that's fine. If
if we don't want it, it's not about, I don't want the president to start engaging us, wasting our money, doing town halls. Sorry, Bob,
thank you.
Wasting money doing town halls.
Thank you, Felicity and Prof. But we've run out of time. Although would like to continue the conversation, nice. But our time is up. We're so grateful to both of you for giving us your time. Prof. Ajimanduya is a governance expert. Felicity Nelson is a member of the Fix the Country movement. We also joined earlier by Bobby Bunsen, who is a legal practitioner, private legal practitioner. Unfortunately, Justice Abdullahi stepped into a meeting and could not join us, but we'll be getting his comments in subsequent episodes of Spotlight. My name is Nwong Falong. Please stay tuned. This evening we have The Dish coming up at 8 p.m. We also have the news coming up right after I get off. On behalf of the entire production team, we would like to thank you for your time. Good evening.